Hey guys, attorney Marc J. Victor here. I'm the founder and owner of the Attorneys for Freedom law firm. Today I want to talk a little bit about DUI. Look, a DUI could either be a misdemeanor or a felony. Let's talk misdemeanors first. First of all, any drug can be the source of a DUI for a person. It doesn't have to be alcohol. It doesn't have to be marijuana. It doesn't have to be just an illegal drug. Any drug that causes a person to be impaired to the slightest degree. Now, that's not very much. The state will have to show that there's some impairment as a result of some drug. Again, it could be illegal drug, legal drug, prescription drug, non-prescription drug, alcohol, marijuana, doesn't matter. If the state can show you are impaired to the slightest degree, they could get a DUI conviction, a misdemeanor conviction. What types of things do they use to show this? Well, obviously, driving. The prosecutor in the DUI trial will point to any kind of a driving error, and there are tons of them. Driving too fast, driving too slow, swerving outside the lines, swerving within the lines, failing to signal, failing to have your headlights on. All these will be argued by a prosecutor to be evidence of the fact that a driver is impaired to the slightest degree. Also, all those games on the side of the road, you know, the ones that there are absolutely no sanction whatsoever for refusing. No sanction whatsoever for refusing all of the tests, games on the side of the road. Most criminal defense lawyers will always recommend that you don't get involved in any of these field sobriety tests while you're pulled over on the side of the road. Because remember, the police officer is judge, jury, and executioner in terms of how you did on those tests. So generally speaking, always a good idea to just refuse them, and also not to make any statements at all on the side of the road. Okay, there's also another section of DUI that we should talk about. We call this the A2 section of DUI. This one pertains just to alcohol. And so we call this the per se legal limit. So if you are driving a motor vehicle or in actual physical control, that's right, you don't even have to be driving a motor vehicle to be charged with a DUI. The state can simply allege that you are in actual physical control. What does that mean? Well, that's up to a jury. Juries will look and consider things like, are you sitting in the front seat? Is the engine running? Are the keys in the ignition? These kinds of things all go to a conclusion about whether a person is in actual physical control. But if the state can't prove that within 2 hours of driving a motor vehicle, your blood alcohol content is a 0.8 or higher, then automatically the state will be able to get a DUI conviction. So this is very important. They do not need to show impairment at all, just that you're 0.8 or higher within 2 hours of driving. Very different than the first DUI we talked about, the A1 DUI, which doesn't require any particular blood alcohol content level. So there's another version of DUI, we call it the A3 DUI, and this generally applies to illegal drugs. If you have methamphetamine, cocaine, heroin, any of the illegal drugs in your system, and the state can prove you have even a trace amount of those illegal drugs in your system at the time that you're driving, you're automatically guilty of a DUI. Now, if it's marijuana, well then the analysis is different. If you have a marijuana DUI, the state will still need to show that you are impaired at least to the slightest degree. And this may be your burden to prove it at trial, not the government's. Okay, so then there's felony DUIs. Remember, a felony is different than a misdemeanor. A felony is something for which you could go to prison for a year or more. That's generally the definition of a felony. How do you get a felony DUI? Well, there's a couple of ways, actually 4 ways to get to the felony DUI range. One way is to get your 3rd misdemeanor DUI within 7 years. Another way is to get one of those misdemeanor DUIs I just described at a time while your license is revoked, canceled, suspended, you have a licensing type of a problem. That's an automatic ticket to the felony DUI world. Another way to get to the felony DUI world is get one of those misdemeanor DUIs while you have a minor, somebody who's under 15 in the vehicle. And then the final way to get to a felony DUI in Arizona is to get one of those misdemeanor DUIs while you're driving the wrong way on the freeway. So we have felony DUIs and we have misdemeanor DUIs. Both of them have mandatory incarceration associated with them. Yeah, even for a first-time misdemeanor DUI, if you're convicted of that, you will have to go to jail for what we say a net 1 day. How do we get to that? Well, it says 10 days, but 9 of them you don't have to do if you voluntarily agree to go to an alcohol screening and do some counseling if it is recommended. There's also mandatory fines. There's all kinds of counseling and things you will need to do. There are licensing problems. Things in the misdemeanor world get more serious if your blood alcohol content is as high as a 1.5 blood alcohol content or even a 2.0. We criminal defense lawyers call that the super extreme DUI, and we have increasing punishments all the way up depending on the level of your blood alcohol content. On the felony DUIs, look, some of these are as serious as a class 4 felony. That means on your first time, you could do up to 3 years and 9 months in prison. And on some of these felony DUIs, there's a mandatory 4-month prison sentence that you have to serve even before you start probation. Also, some of the felonies carry up to a 3-year license revocation. Look, DUI is a really serious crime. If you're charged with a DUI, you're going to need somebody who can aggressively take a look at the case. And there are many ways to fight a DUI. Don't fret. A good criminal defense attorney will look carefully into the traffic stop, the searches, the chemical tests. There are many ways to fight DUIs. We've had many, many DUIs dismissed over the years or reduced over the years. If you are facing a DUI charge, get a qualified, experienced, aggressive criminal defense attorney on your side. Check us out online. Take a look at our Google reviews. Take a look at all the information you can find. We'd be happy to help you get through the DUI charge. For $100, we'll sit down with you. We'll conduct a strategy session. It'll take about an hour. This is the time it takes to properly go through your case carefully so we can understand everything that's going on. And then we can give you a comprehensive evaluation of exactly what it is you're looking at, what our strategy would be to get you through it. Give us a call. Check us out, attorneysforfreedom.com. Thanks for listening.